Welcome to the Deep Dive. Today, we're diving into the world of technology law and data privacy. It's always changing, right? And you shared a really fascinating report with us. It's called Technology Law and Data Privacy Updates from Fountainhead Legal. And wow, it is packed with international legal developments. So are you ready to jump in?
Absolutely. It really highlights how global this whole issue is becoming. Legal systems all over the world are dealing with very similar challenges, like how AI is affecting copyright, how data protection is evolving. It's a lot.
It really does feel like we're at this point where the digital world is kind of hitting up against like real world laws.
Yeah, that's a great way to put it. Like the rules are being rewritten literally as we speak. And
Right.
it's so important to understand what's changing.
Okay, so let's start with India. I mean, they've been busy on the regulatory front, haven't they? I noticed the report mentions like new developments with OTT platforms, telecom fraud. They're even addressing web scraping. I mean, what's driving all of this activity?
Well, I think India is really trying to find a balance. They want to encourage innovation and digital growth, but they also, want to protect citizens' rights and prevent technology from being misused. So take OTT platforms, for instance,
Hmm.
those streaming services, right? Super popular, exploding in popularity. But there's been growing concern about how the content is regulated, especially regarding, what's appropriate for different age groups and, sensitive material.
So it's kind of like the Wild West out there, and they're trying to, establish some law and order.
Exactly. That's a great analogy. The government's basically issuing these advisories to these OTT platforms. It's essentially saying, look, you guys are responsible for what's on your platform. Make sure it's, aligned with our content guidelines. It's like a reminder that, the digital world isn't just this lawless frontier.
Yeah, and it's not just content, right? I mean, they're also cracking down on social media platforms that are hosting content that promotes telecom fraud.
That's right. Things like caller ID spoofing, IMEI manipulation,
Yeah.
these are serious problems. And the government is, being proactive. They're holding these social media companies accountable for the content that's on their platforms, pushing them to actually remove those posts that promote this fraudulent activity.
So it sounds like they're sending a pretty strong message,
Yeah.
like clean up your act or you're going to face consequences.
Yeah, it is a strong message. And this focus on responsible data practices extends to web scraping as well.
Web scraping. So that's when companies like automatically collect data from websites, right?
Yes. It's used for things like market research, sometimes even for training AI models. And now the Indian government has actually clarified how web scraping is regulated under existing and upcoming laws, specifically the IT Act and the new DPDP Act. That's the Digital Personal Data Protection Act of 2023.
It's interesting. It seems like India's saying, look, we're all for the digital age, but we're going to set some clear boundaries.
Exactly, precisely. And these boundaries, have huge implications for businesses that operate in India, particularly those businesses that are involved in data-driven activities like AI development.
So companies need to pay close attention to these regulations, even if they're, operating outside of India.
Absolutely. These developments signal a global shift towards like stricter data protection and more responsible use of technology. And speaking of global shifts, let's turn our attention to the European Union. The new AI Act is starting to make
I
waves.
was just about to say, this AI Act feels like a really big deal. The report mentions that the European Commission issued guidelines, right, to define what actually constitutes an AI system. It feels like they're really trying to pin down some like slippery definitions.
It's essential, right? I mean, the AI Act is a complex piece of legislation, and these guidelines offer some much needed clarity. They outline seven core elements that help determine if a system qualifies as AI, things like autonomy, learning capabilities, how it interacts with the environment.
So it's almost like a checklist for developers to help them figure out if their creation actually falls under the AI Act's rules.
Exactly. But here's where it gets interesting. The report also highlights this potential tension between the AI Act and GDPR, the General Data Protection Regulation.
Ah, yes, GDPR. The EU's data privacy, like champion. What's the conflict there?
Well, it all revolves around AI bias detection. So the AI Act encourages data processing to identify and correct bias, right? Which is a good thing, of course. But GDPR, on the other hand, has very strict rules about processing sensitive personal data, which is often needed to detect and mitigate bias in AI systems.
So like a catch-22. We need to process data to make sure things are fair, but that processing itself might go against data privacy rules.
Exactly. That's exactly it. And the report suggests that this could create some compliance challenges for companies. They might need some clearer guidance, maybe even legislative changes to resolve this tension.
It seems like even with the best intentions, trying to create these regulations, effective regulations, for something as complex as AI, it's a tough job. It's a balancing act. And it'll be really interesting to see how this plays out.
Agreed. Now, while the EU is grappling with these complexities, the US is facing its own set of legal challenges related to data privacy.
Oh, right. The report mentioned that class action lawsuit against Amazon over their data collection practices. What's the story there?
So Amazon is being accused of unlawfully collecting geolocation data, and this includes data that could reveal visits to sensitive locations, like medical facilities, all through their advertising SDK.
So they're not just tracking where you shop, they're potentially gathering information about your health and like other really private stuff?
That's the allegation. The lawsuit claims that Amazon used this data for targeted advertising and even sold it to third parties, and they did it without proper user consent.
If the plaintiffs win this case, I mean, could that have like a ripple effect throughout the entire digital advertising industry?
Absolutely. It could force companies to be a lot more transparent about how they collect data, how they use it, how they share user data. But Amazon's not the only one facing legal scrutiny. The report also mentions that Home Depot lost an appeal related to that 2014 data breach.
Oh, yeah, that was a huge breach. I think hackers stole millions of customers' payment card details, if I remember correctly. What was the appeal about?
So Home Depot tried to claim insurance coverage for the financial losses that they suffered because of that breach. However, the court ruled against them. They said that essentially that the company's general liability policies didn't cover losses related to electronic data breaches.
Oh, wow. So even though they had insurance, it didn't protect them from the financial fallout of a cyber attack. That's a hard lesson to learn.
It is, and it highlights a crucial point for really any business. Don't rely solely on insurance to protect yourself from these cyber risks. Investing in solid cybersecurity measures is so important. This ruling just shows that hoping insurance will cover everything, it's not a good strategy.
It's a wake-up call for businesses to really take data security seriously. You can't just pass the buck, to an insurance policy.
That's right. Proactive risk management is essential in today's digital landscape. And, speaking of proactive approaches, Australia has been busy strengthening their data protection and cybersecurity framework.
Yeah, they've been making headlines with their new legislation. What have they been up to?
Well, Australia enacted a new privacy law in Western Australia, and they also made some significant changes to their AML-CFT regulations. Those are focused on anti-money laundering and counter-terrorism financing.
So they're tackling data privacy and financial security in the digital world. They're really stepping up their game.
They are. This new privacy law, the Privacy and Responsible Information Sharing Act of 2024, creates a chief data officer to oversee data governance. It also requires data de-identification measures when personal information is being shared. Plus, it enhances transparency by making government-held data more accessible to the public.
It seems like they're finding that balance, right? Protecting individuals' privacy, but also enabling responsible information sharing. What about the AML-CFT changes? What's driving those?
Well, they're expanding the scope of AML-CFT obligations. They're now including more professionals like lawyers, accountants, real estate agents. They're also tightening the rules on virtual asset service providers, VASPs, and broadening the definition of digital assets to include things like NFTs and stablecoins.
So they're keeping pace with the changing landscape of digital finance and trying to prevent financial crimes in this new world.
Exactly. They're acknowledging that financial crime isn't limited to those traditional banking systems anymore. It's happening in cryptocurrencies, in digital assets, and they're taking action to address those risks.
Makes sense. And it just shows how interconnected all these issues are. Data privacy, cybersecurity, financial regulations, they're all linked together in the digital age.
Absolutely. It's a complex web, and it's important to understand how these developments are shaping the legal landscape globally.
We've covered a lot already, from India's approach to digital regulation to the EU's AI Act and all those data privacy challenges, and now Australia's stance on data protection and financial security. But before we go any further, I'd love to hear what's resonating with you, dear listener. What stands out from all of this? What questions are you thinking about? Take a moment to consider that as we continue our deep dive into the legal side of the digital world.
Okay, so let's get back to the Fountainhead legal report. We've got more to cover in the EU, and then we'll hop over to the US, where things are getting interesting.
Perfect. I'm ready.
Nah.
Last we left off, you were talking about the possible conflict, between the EU's AI Act and GDPR, especially when it comes to bias detection. Anything new there?
Actually, there is. The CJEU, that's the Court of Justice of the European Union, recently made a ruling, and it clarifies a really important point about pseudonymized data in GDPR.
This is related to that whole balancing act we were discussing before, right? Trying to protect people's privacy while still allowing data to be used responsibly.
Exactly. You see, pseudonymization is a technique, a common one, that's used to protect data. It basically involves replacing identifying information, like names and stuff, with artificial identifiers. It makes it harder to link the data back to a specific person.
So it's kind of like giving someone a code name instead of using their real name.
Yeah, that's a good analogy. But the question the CJEU is trying to answer is, does pseudonymized data still fall under the rules of GDPR?
That's a good question. It seems like if you've removed the obvious identifiers, it shouldn't be a problem, right?
Well, not quite. The court actually ruled that even when data is pseudonymized, it's still covered by GDPR if any entity, whether it's the data processor or someone else, can re-identify those individuals.
So it's not enough just to kind of mask the data. You have to think about whether someone, somewhere, could potentially figure out who it belongs to.
Exactly. That's a key point. The court stressed that pseudonymization is definitely valuable for data security, but it's not like a get-out-of-jail-free card for ignoring GDPR. If it's possible to re-identify someone, those data protection rules still apply.
Sounds like companies really need to be careful about how they handle pseudonymized data. They can't just assume it's exempt from those privacy regulations.
Absolutely. This ruling sets a high standard for data protection. It really emphasizes that the focus should always be on protecting individual privacy, even when techniques like pseudonymization are used.
It reminds us that technology moves so fast and the law is always trying to catch up to make sure these advancements don't, step on people's rights.
Well said. And while the EU is thinking about those big picture data protection questions, Switzerland is focused on something, well, a bit more specific: cookies.
Ah, yes. Cookies, those little digital crumbs that follow us everywhere online. I feel like I'm constantly being asked to accept cookies. What's happening in Switzerland?
So they've issued some new guidelines that aim to provide a clearer framework for how websites can use cookies, to collect and process data.
So they're trying to bring some order to, like, the Wild West of cookie consent pop-ups.
You could put it that way. The guidelines really stress transparency, informed consent, and safeguards against what they call dark patterns, those sneaky things we see online.
Dark patterns. Oh, you mean those tricky designs where it's like super easy to accept cookies, but then it's a nightmare to decline them.
Exactly. Think about those pre-ticked boxes, those confusing button designs, all those subtle nudges, to get you to share more data than you really want to. The Swiss guidelines are recommending what they call a two-click solution to block those third-party tracking scripts until the user actually gives their consent. And they also want websites to make it just as easy to reject cookies as it is to accept them.
It's about time. I'm so tired of feeling like I'm being manipulated into accepting cookies. It should be a clear, simple choice.
I agree. These guidelines are a really positive step. They're putting users back in control of their data. Now, while Switzerland is tackling cookies, Austria has been dealing with a different kind of challenge, trying to find the right balance between transparency in AI and, trade secret protection.
That sounds really difficult. I mean, we want to understand how AI systems are making decisions, especially when those decisions affect our lives. But companies also want to protect their intellectual property.
Yeah, you've got it. There was a recent preliminary ruling from the CJEU, and it offers some guidance on this. The case was about a consumer who was denied a mobile phone contract. It was based on a credit rating that was generated by an AI system, and naturally this person wanted to know how that decision was made, invoking their rights under GDPR.
It does seem reasonable. You want to know why you're denied credit,
Yeah.
especially if it's some mysterious AI making the call. What does the court say?
So they ruled that companies that use AI for decision-making, they have to disclose the main parameters, the weighting factors, and the personal data that's used in the process. However, they also acknowledged that some of the technical details of how that AI algorithm works might be considered trade secrets.
So it's a delicate balance.
Exactly.
Right.
Companies can't just hide behind trade secrets and refuse to explain what their AI is doing. They need to provide enough information so individuals can, assess whether that decision was fair and unbiased without necessarily revealing the secret sauce of their algorithm.
That sounds like a win-win. Transparency for consumers, protection for companies, intellectual property.
It's definitely a step in the right direction. Now, let's shift gears and go back to the US. There's another legal development happening there, and I think you'll find it pretty interesting because it relates to data privacy.
I'm intrigued. Tell me more. What's going on?
Remember that class action lawsuit against Amazon, the one about geolocation and health data collection? Well, there's another lawsuit, this time in Arkansas, and it accuses General Motors and their OnStar subsidiary of, get this, secretly collecting and selling consumer driving data.
Wait a minute. So even if you haven't signed up for OnStar, they could still be collecting data about how you drive.
That's what the lawsuit is claiming. It says that GM's telematics system is tracking things like speed, acceleration, braking habits, even location data. And it's happening even for drivers who aren't enrolled in OnStar.
That's a little creepy, isn't it? You're just driving along thinking it's you in the road and your car is recording all this information about you.
And the lawsuit goes further. It argues that this data was then sold to data brokers, who then turned around and sold it to insurance companies. And this could potentially impact consumers' insurance premiums and even coverage decisions.
Wow, that raises some serious questions about consent and transparency. Are we unknowingly agreeing to this kind of data collection just because we drive a car that has these telematics systems?
That's the big question here. If this lawsuit is successful, it could have big implications for how companies collect and use data from these connected vehicles.
It's a reminder that data privacy isn't just about our phones and computers. It's about our cars, our homes, all these interconnected devices in the Internet of Things.
Absolutely. And while we're on the topic of expanding regulations to cover new technologies, let's go back to Australia for a moment. We talked before about their efforts to strengthen those AML-CFT regulations. Anything specific to mention there?
I'm all ears. What's happening down under?
One of the big changes is the implementation of what they call the travel rule. This is becoming a kind of international standard, and it basically requires financial institutions, including those dealing with cryptocurrencies, to share certain transaction information when funds are being transferred.
So it's like a digital trail for money.
Mm-hmm.
Makes it harder to hide those illegal activities.
Exactly. It's designed to bring more transparency, make it tougher for criminals to launder money or finance terrorism using digital currencies.
It sounds like Australia is trying to apply the same level of scrutiny to the digital asset world that we see in, traditional finance.
That's right. They've also broadened that definition of digital assets. Now it includes things like NFTs and stablecoins. This puts them under the umbrella of AML-CFT regulations. It's all part of this big effort to stay ahead of the curve in digital finance and prevent financial crime.
Makes sense. The criminal world is always looking for new ways to exploit things. Regulators need to adapt.
Definitely. Now, while Australia is focused on financial regulations, the UK is making progress on addressing online safety, especially when it comes to gender-based harms.
That's important. We talked before about their updated guidelines for employee data, but what are they doing about online harms?
They've released some draft guidelines, and they propose tougher measures for those online platforms to address things like online misogyny, harassment, and image-based sexual abuse. These guidelines are part of the Online Safety Act of 2023.
So they're taking a proactive approach. What are some of the key points in these guidelines?
One big focus is this idea of a safety by design approach. This basically means that companies need to build those safety features into their platforms from the very beginning, instead of just reacting to problems after they happen.
So like baking safety into the very DNA of those platforms.
Yeah, exactly. They're also suggesting the use of AI-powered content moderation to help identify and remove harmful content quicker and hopefully more effectively.
Using technology to fight the misuse of technology.
Exactly. They're also emphasizing strong reporting mechanisms and clear consequences for those who are engaging in that online abuse. It's a multi-pronged approach, and the goal is to create safer spaces online for everyone.
It's good to see governments taking these issues seriously. It's a reminder that the digital world can be a force for good, but it definitely has a dark side, and we need to address that.
I couldn't agree more. And speaking of addressing the complexities of the digital world, let's revisit that landmark ruling from Hong Kong about DAO governance and financial oversight.
Yes, that case really shows how challenging it can be to regulate these decentralized organizations. Can you remind us about what happened there?
It involved allegations of financial misconduct within a DAO. The court decided that even though DAOs are decentralized, they still have to follow legal and financial rules. It was a big win for transparency and accountability in that whole DAO space.
This is like the Wild West days of the crypto world. They're, slowly coming to an end as those regulations catch up.
Maybe. But it's important to remember that regulation isn't always about, stopping innovation. It can also create a more stable, more trustworthy environment, and that ultimately helps everyone.
Very true. We've covered so much in this section, how data privacy regulations are changing in Europe, how those concerns about data collection are extending to our cars in the U.S., and how Australia is working to keep up with digital finance.
And let's not forget the UK and their efforts to address online safety and that groundbreaking ruling in Hong Kong that brings DAOs under the rule of law.
Okay, before we move on to the last part of the Fountainhead Legal Report, I want to ask you, dear listener, what's sticking with you the most? What are the key takeaways you'll remember as you navigate this complex and, frankly, ever-changing digital world? Take a moment to think about that as we get ready to wrap up our deep dive.
All right, we're back. Ready for the last part of our deep dive into technology, law, and data privacy.
I am. Let's finish strong. What else is in that Fountainhead Legal Report?
Well, we still have a few areas to look at. Let's go back to the UK and Hong Kong for a bit. They've both had some interesting developments that are worth talking about.
Sounds good. Let's start with the UK. We discussed those new guidelines for how they handle employee data under UK GDPR, but I'm really curious about what it means for employers in practice. What are the main things they need to remember?
Well, those guidelines are all about promoting responsible and transparent data practices, right there in the workplace. They cover a lot of different topics like the legal reasons for collecting employee data in the first place, how long they can keep that data, security measures, and what rights employees have.
It sounds really comprehensive, like a whole framework for making sure that employee data is handled carefully.
It is. Employers have to set up clear policies and procedures for collecting and processing employee data. And, really importantly, they need to be open with their employees about what data they're collecting, why they need it, and how they're going to use it.
Transparency seems to be a big theme in all of these legal developments.
For sure. Individuals have a right to know what's happening with their data. It doesn't matter if it's their work data, their online browsing, even their driving habits.
Right. It's all about giving people the power to make their own decisions about their data.
Exactly. Okay, let's shift gears over to Hong Kong now. We talked a little about that court ruling, the one that clarified that DAOs still have to follow financial rules. That case caused quite a stir in the crypto world. Can you walk us through the details? Why was it so important?
Of course. So the case was about a disagreement over, financial control and how assets were being managed within a DAO. The plaintiffs were saying that the defendants had basically taken control of the DAO improperly and were misusing funds from the project. But the defendants argued that DAOs are, by their very nature, decentralized. They said they're governed by the people who hold tokens, not by one specific entity. It was a classic clash between those traditional legal ideas and the whole new structure of DAOs.
Right, so it was kind of a test case for how the law should be applied to these new decentralized organizations. What happened?
Well, the court ended up siding with those plaintiffs. They issued something called an accounts disclosure order, and it forced the defendants to hand over detailed financial records.
That sounds like a big win for making things more transparent and accountable in the DAO world.
It is. It sets a precedent, basically saying that even though DAOs are decentralized, they're not above the law. They have to operate within the rules and meet their financial obligations.
Right. It's a reminder that just because something is innovative, that doesn't mean it gets to ignore the rules.
Absolutely. This ruling clears things up a lot for the future of DAOs. It shows that the legal systems are catching up to this new technology and figuring out how to make sure they're governed responsibly.
Definitely. Wow, we have covered a lot in this deep dive. We looked at legal stuff in AI, data privacy, how digital content is regulated, cybersecurity, even those DAOs. It's been a journey.
It has. And it really highlights how fast things are changing in technology law. New challenges and new opportunities are popping up all the time.
Yeah, it's exciting to be following all of this. The choices being made right now will shape the digital world for years to come.
And that's exactly why it's so important for all of you listening to stay informed. These changes affect how you interact online, how companies use your data, even how AI develops in the future.
It's a complicated world out there, and it's only going to get more so. But if you stay engaged and ask good questions, you can navigate all of this with confidence.
So as we wrap up this deep dive, I really encourage you to think about what you've learned. What insights are you taking away? What questions are you going to keep thinking about? Understanding technology law and data privacy is a journey, and it's ongoing. I hope this deep dive gave you a good starting point for finding your way through it all.